Thomas Höppner, Alessia D'Amico, Renato Nazzini, very warm welcome to the Digital Markets Research Hub. I'm very grateful for your time and your expertise. We will be discussing today one of the most landmark and impactful recent judgments of the Court of Justice of the European Union on Meta saga. We know that there are several potentially important implications and avenues where this case can recalibrate current practices and evolution of different policies. Data protection and competition are among the most obvious ones. And because of your expertise and our main focus, we have decided that we will be discussing mainly competition policy niche, so to say. So without further ado, I propose that we'll start with just maybe reminding the facts of the case. And why wouldn't we start with you, Renato?
Thank you very much, Ulrich. Thank you very much for the invitation. I'm very pleased to be here to discuss this important judgment. Indeed, interaction between data protection, privacy rules, and competition has been one of the very big topics recently. So just as a very brief reminder of the facts of this case, so we all know Facebook, now owned by a company called Meta, and in particular for our purposes, Meta Ireland. The case concerns the operations of Facebook in Germany. And Facebook in Germany, but that was actually a much broader business model, of course. But the main subject matter of the case was the way that Facebook obtained data that then from the users, data that then are used to build a profile of the user in order to monetize the free social network services by selling advertising space and selling advertising which is specific to the profile of that individual user. So we joined Facebook, so German users rather joined Facebook, and they gave Facebook consent to obtain and process their data, which they provide by using Facebook. But they also had, and they did not have any choice but to agree to Facebook gathering and processing and using other data that users provided in two ways, either by using other Facebook services, notably WhatsApp, Instagram, and others, or by using third-party websites which had an interface or cookies that allowed them to provide data to Facebook. So very broad, so social services data, but also off Facebook data. Now, the Bundeskartellamt, the Federal Cartel Office, the German competition authority, took objection to this conduct, and it took objection particularly to the necessary consent to Facebook to use off Facebook data. So data on other meta services, WhatsApp, Instagram, and data on third-party websites. What the Bundeskartellamt said in its decision of the 6th of February 2019 was that Facebook and Meta were abusing its dominant position on the social network market by not giving users a choice not to allow them to gather and process data on other meta services, WhatsApp and Instagram, etc., and on third-party websites. And essentially, I mean, it's a long decision and a reasonably complex decision, but it seems to me that the essence of the decision was that such a consent was in breach of the General Data Protection Regulation, because it was not a consent which was freely given, because Facebook was a dominant company, and in order to use Facebook services, the social network services, users had no choice but to agree to this broader data gathering consent. That was a breach of the GDPR, and it also amounted to an abuse of dominance under the antitrust rules because the Facebook dominance allowed it to carry out this particular conduct. And the Bundeskartellamt, we'll perhaps discuss it a bit later, but the Bundeskartellamt, again, it seems to me, categorized this abuse as an exploitative abuse. So an abuse which is exploitative of users. Facebook was essentially getting from users too much. Now, Facebook was not happy with this decision. Perhaps I don't talk about the remedy. We'll talk about it a bit later. It's not the main issue in the Meta judgment, although I think it's quite interesting. Maybe if we have time. But Facebook, Meta were not happy with the decision. Of course, they challenged the decision first before the court of first instance, which is the Oberlandesgericht Düsseldorf, the higher regional court of Düsseldorf, which suspended the enforcement of the decision, clearly having perhaps some doubts as to its validity. But then the case went to the Federal Court of Justice, which revoked the suspension order, saying that there weren't serious doubts that this conduct was an abuse of dominance. The case, therefore, needed to be decided on the merits by the higher regional court of Düsseldorf, which then referred a number of questions to the Court of Justice, which gave rise to this judgment. And I think that's my first task accomplished. Thank you.
Thank you very much. Thank you very much indeed, Renato. Let us now move to Alessia and ask her to continue with this chronological exposition of the stages up to the point of including the opinion of Advocate General Rantos on the case.
Yeah, thank you very much. Thank you very much for having me, and thank you, Renato, for this great summary of this very complex and very long decision. So I will just focus on the matters that are around the interface between competition law and data protection. And here the main questions that I find relevant in this regard are question 1 and 7, which the Court of Justice answered together, but the Advocate General looked at separately. And then question 6, which some might think is not entirely relevant for this discussion, but I will show you how it is relevant for this discussion. So the first question referred to the Court of Justice is whether a competition authority is able to decide, and this is the understanding of the Advocate General of the question. So if a competition authority is able to decide as the main issue, and these are the key words, as the main issue on a breach of the GDPR, and then to order to the company to put an end to that breach within the meaning of the GDPR. And here the Advocate General said that this is not what the Bundeskartellamt did. It did not, according to the Advocate General, penalize a breach of the GDPR and and didn't tell Meta that it should stop the behavior because of the GDPR breach, but it brought an abuse of dominance case. So the Advocate General said this question is irrelevant, and then moved on to the question 7, which is a light version of the first question, which is whether competition authority can, when prosecuting an infringement of competition rules, so when finding an abuse of dominance, decide as an incidental question whether the data processing terms comply with the GDPR. Interestingly, I find here it doesn't talk about breach, like if it can find a breach of the GDPR, it always talks about whether the terms comply or not, or are coherent with the GDPR. And here the Advocate General said that although a competition authority is not competent to establish a breach of the GDPR, so it does now answer question 1, it does not, so the GDPR does not preclude other authorities when exercising their own powers from taking it into account as an incidental question whether the conduct is compatible with the GDPR or not. So what this means is that competition authorities, when considering all the circumstances of the case, they can also regard GDPR rules. And here the Advocate General says this is it can be a vital clue, and then the Court of Justice also repeats those words. So the GDPR compliance can be a vital clue as to whether the conduct in question is an abuse of dominance or not. So whether it is competition on the merit or not. So in this regard, it is possible for competition authorities to look at GDPR and stressing many times that it does so when finding an abuse of dominance, just in an incidental way and not actually enforcing GDPR, because this is what data protection authorities are there to do. So this was very briefly the questions 1 and 7, which I think this is what we will focus on. But I also think that the question 6 is relevant when thinking about the interface between competition law and data protection, because this question asks if under the GDPR, when establishing whether consent is valid, and one aspect of valid consent is whether consent is freely given, dominance is a factor that can be taken into account. So whether data protection authorities can say that because of the dominance of a company, consent is not freely given and therefore is not valid. And here the Advocate General said that the dominant position can be a relevant factor when establishing freely given consent, although the circumstance alone cannot render consent invalid. And then it also says, and the Court of Justice does not repeat this though, that consent dominance does not have to be dominant under Article 102. So it can be something else, we don't know what. But I think this is relevant, and if we have time and if you're interested, we can talk about it later. I think it's relevant when we think about, well, who's better placed to do what, who should bring a case, and if data protection authorities can actually have regard to dominance in their enforcement, then maybe they are able to do things that we thought just competition authorities can do. So that's why I think it's relevant, and yeah, looking forward to the discussion.
Thank you very much, Alessia. I think this is a really intriguing question. And before looking at more subjective side or your personal views as academics, as competition law thinkers, I wanted to ask Thomas to finish with this more neutral, objective, expositional part of our conversation, and to provide us a summary of the main answers of the Court of Justice to this preliminary rule request.
I think we should first think of one other element, one level, because we want to go through it chronologically. I think we should not forget about the Federal Supreme Court, German Federal Supreme Court, which, and I find this is an important feature of the case, never really bothered with all the GDPR issues, but found an abuse of dominance based on a different theory of harm. So it put those issues aside, and it created a theory where none or almost none of the questions that were then brought forward by the appeal court to the Court of Justice really play a significant role. And I think this is important to keep in mind, because it could mean that the current ruling of the court will not ultimately manifest itself in a different outcome in the main proceeding in Germany. And the reason is that the Federal Supreme Court basically saw the harm elsewhere. It said more that the problematic aspect was that users were not given sufficient choice, a choice between a product with less personalization and one with more personalization. And to put it simply, I think you could really compare it with a kind of a bundling, where the concern is Facebook extended its offerings to an extent that maybe consumers did not want to, or at least they should have been asked whether they want such extension. And the court leaves it open whether such extension of the service was a type of bundling of a kind of a new personalized version to the old unpersonalized version, or just an extension of the original service. In any case, in the view of the court, Facebook should have asked its users whether they agree to such extended use of their data. And there could have been situations where some do because they wouldn't have liked to pay, but others don't because they realize that the more content, the more data they give, the more in revenues Meta can generate. But I find that quite intriguing because it also explains that you probably didn't really have to go through all this depth of GDPR analysis to solve the case and find an abuse. So if we now look at the Court of Justice, we have to keep in mind that these were kind of answers to questions that, according to the Federal Supreme Court, are not relevant, right? So they were asked by a judge that had a different theory and maybe also wanted to annoy a bit the Federal Supreme Court by asking these questions, but ultimately they will not be decisive for finding an abuse when you follow the theory of the Federal Supreme Court. But coming back to your question, I think in the outcome is rather kind of, you can see that from the summary of the court's judgment, is rather clear that the fact that there are specialized authorities for enforcement of GDPR does not stop the National Competition Authority from pursuing their task, which is to apply competition law. And if in this process of applying competition law, it is necessary to look at the legal framework for a certain conduct, also to identify the significant parameters that determine competition in that area, then they can and sometimes have to, it's not a new thing, can and have to look at the current legal framework, including the GDPR. That does not turn them into a privacy enforcement authority, because they are still not enforcing privacy laws, but competition laws. It just means that they apply the law and analyze the law. And then the second aspect of the court is the concept of cooperation. So because under European primary law, national authorities should really cooperate with European enforcement institutions and also cooperate amongst each other, there is a need that if a competition authority wants to analyze the compliance with GDPR, it should, wherever appropriate, consult and cooperate with the enforcement authority for the respective privacy law, so that they find, if you like, a common line and don't contradict each other. I think this is more like of a matter of procedural efficiency to avoid that two authorities dealing with the same laws come to different outcomes. And I think this makes sense. There are some risks in it that one authority may just rely on the other, and then the other one may take too long, and then it just makes the whole enforcement process less efficient. We can turn to that later. The court kind of addressed this and said, if the privacy authority doesn't answer or doesn't answer in a reasonable time, you can move on individually. So I think this is actually a nice balance, but we are not in the analyzing part yet. Regarding then the GDPR issues, I think that is less kind of relevant for the competition debate, apart from what I found interesting and important. The general question, can any type of consent that you give if the firm is dominant actually be valid? And I think that could have been generalized very quickly, that you could see, well, whatever you agree to, if it's a dominant company that you have on the other side, it's not valid. I think that would have had quite far-reaching consequences also under competition law, but the court didn't go that far. It said that it's not per se invalid, but you have to take these issues of dominance into consideration when weighing up whether it's still voluntary. So kind of is a half and half answer, and have to consider it, but it's not per se invalid then.
Thank you very much, Thomas, for this. Let us move now to discuss the most important, most emblematic implications of the case, and maybe from more from the theoretical side start. And the first question: was this road chosen by the national judge the only plausible? Thomas somehow highlighted that there were other instances, other ways to establish abuse of dominance, and also Alessia mentioned implications, potential implications that could it lead to kind of Pandora box that all authorities can enforce, even if it incidentally, whatever it means, other areas of law. Is it normal for in this more interactive, more pluralistic stage of the development of EU law more generally, Renato, or is it something extraordinary and we just have to learn and try to adopt our juristic minds to this emerging technical reality?
Well, thank you. That's I think one perhaps the crucial question in the case. And what I would like to, in order to answer that question, if you allow me to take again a step back, because I think these ideas of theories of harm is quite important, because at the end of the day, the theory of harm is the competition theory of harm. And that's key to the reasoning of the Court of Justice, because what the Court of Justice said, okay, you can, look at the GDPR, but as long as this is for enforcing the competition rules. So I think we are faced with a number of possible theories of harm here in relation to this conduct that the Bundeskartellamt, that the German Federal Cartel Office looked at. So I think Thomas has already explained the Federal Court of Justice. I understand that in Germany, perhaps like in the UK, an appellate court can substitute its own reasoning for that of the authority. For example, that would not be the case in Italy. It would be the case in the UK, obviously, when we have appeals on the merits. But the point is that I don't think that's what the Bundeskartellamt did, actually. I don't think that was the reasoning of the Bundeskartellamt, because the reasoning of the Bundeskartellamt and the decision of the Bundeskartellamt was, this is a breach of the GDPR by a dominant company, or forcing users to give consent beyond what is necessary. This consent is invalid, and therefore this is an abuse. So it was not forcing a new service or a new product which is not necessarily linked, etc. Which, by the way, can be an exploitative abuse. I mean, we have a case law, not a massive case law of the Court of Justice, but going back to cases like the collecting society cases, like BRT and Sabam, for example, by the Court of Justice, where the Court of Justice effectively said, are these clauses unfair? Are these clauses exploitative? And what the Court of Justice said, we were talking about 40 years ago, it said, well, you have to look at the balance of all the interests of the authors, of the collecting society. It's kind of balancing proportionality test. So I think that's, that gets closer to what the Federal Court of Justice said. But I think there is also a third theory of harm, which is the theory of harm that now it's also in section 1984 of the new amendment to the German law on restrictions of competition. And it's a theory of harm which is kind of hinted at in the decision of the Federal Cartel Office, but not really pursued, which is collecting excessive data, a huge amount of data, which only a dominant company can do by forcing this extensive consent by users, creates or raises a barrier to entry, which makes more difficult or impossible for other social networks to enter the German market. That for me would have been the real competition theory of harm. Okay, so but there are a couple of paragraphs in the decision of the Bundeskartellamt, but it doesn't seem to me that it's the main reasoning and foundation of the decision. Now, looking at all of this, what do I think about the answer of the court? I think it would be extraordinary if the court had said a competition authority should just be blind to the GDPR and whether something complies or does not comply with the GDPR. I think that would have been really extraordinary. Yeah, of course, I think the Advocate General and the court on this are fundamentally right. I mean, when you look at conducts, and particularly whether conduct is competition on the merits, you look at the general legal and market context, you can look at whether conduct does comply or does not comply with other rules. However, I think this should be, perhaps this is where the court really didn't go. I mean, didn't say one thing or another. Whether conduct complies or does not comply with other rules is never really the end of the matter, because at the end of the day, what you have to look at is whether this is an infringement of the competition rule. This is an abuse of dominance. Now, the breach of the GDPR or non-compliance with the GDPR can be a relevant factor. I mean, clearly, if something is unlawful or even patently illegal. I mean, think about a dominant company burning the research and development facilities of a competitor, right? It's quite difficult to argue, oh, this is competition on the merits, right? I mean, yeah, it's not. But there must be something more to the competition infringement than mere arson, which is a crime or can be a tort, right? So there must be an anti-competitive effect. So the gist, I think, of the analysis of the court there, looking at compliance or non-compliance with other rules is one factor, which is cannot be decisive, but it's a relevant element in the general legal and economic context. I think that is not wrong. I think what is wrong, and I do think that the decision by the German Competition Authority comes close to that. What is wrong, would be wrong, is to say, you are dominant, you breach the GDPR, hence this is an exploitative abuse, without anything else, because this is like a duplication of the GDPR infringement, and that should not be allowed. But the legal principle, I think it's okay as far as I'm concerned.
Thanks a lot, Renato. Alessia, how do you see this correlation between two areas of law and judicial kind of philosophizing on these matters?
Yes, thank you. So I will pick up on the last thing that Renato mentioned, which is we shouldn't allow a system where a breach of the GDPR automatically becomes an abuse of dominance just because the undertaking is dominant, right? We don't want that. I think, so I've been thinking a lot about what the judgment means for exploitative versus exclusionary abuses, because the court mentions in its main paragraph, it talks about taking into account compliance with the GDPR when thinking about the effects of a certain conduct on competition on the market. So it talks about repeatedly about the effects. So we can take into account GDPR when thinking about how conduct could damage competition. So for me, when I read the judgment, I think mostly about exclusionary abuses, which I think there it's quite uncontroversial. I think, and I think there I think we all agree that it makes sense that GDPR might be relevant when thinking about an exclusionary abuse. And why wouldn't a competition authority do it? For instance, we see a company, gathering excessive amounts of data, and by doing that, it can distort competition and exclude others from the market. Well, we have an easy, in a way, competition case where GDPR is incidentally relevant, like the Advocate General says. Well, it becomes more complicated when we have an exploitative abuse, because there it's not about looking at the effects on the market, but it's more looking at, well, is this conduct exploiting users? And there it's harder to draw a line, I think, between competition authorities legitimately bringing a competition case where they say, well, this is an abuse of dominance and it's manifested with excessive data collection, for instance, and them saying, well, this is an abuse of GDPR, this is a breach of GDPR, and we say it is also an abuse of dominance because the undertaking is dominant. And so I think there the judgment is quite vague. I don't really, I don't know what to make out of it, because also the Bundeskartellamt decision there is also not so clear when it comes to the type of abuse it is, because it talks about an exploitative abuse, but then, and this is the whole the judgment of the Düsseldorf court really goes into that, and it says, well, the Bundeskartellamt didn't actually look at the counterfactual. There was no causality proven there, because what the Bundeskartellamt did is say, well, Meta was collecting too much data, this is a breach of GDPR. But it didn't show that it could only do that because it was dominant. It said, well, you know, let's think about causality a bit more like broadly, and we kind of have this effect, I don't know how it's translated, like effects causality. Well, this conduct can also harm competition. And that's why we say that there is some cause. But for me, it seems like kind of mixing the two theories of harm, an exclusionary and an exploitative, and it's not very clear there, which for me now makes it unclear if, you know, how to draw a line in exploitative abuse cases, because I think there is no clear answer in the judgment there. But please, others, feel free to disagree with me.
Come back, sorry, Tom, just come back on that very, very quickly, because basically also, you know, I agree totally. I mean, and, you know, I would have liked the decision to be about barriers to entry and excessive collection of data that only a dominant company can, like Facebook, can do. I mean, if that, you know, whether on the facts, you know, of course, I haven't seen the file, right? But, you know, if on the facts you can prove that that's an exclusionary abuse, and I'm happy. But where I'm not happy is really this, as you say, this murky area. You know, you are dominant, there is a breach of the GDPR, hence it's an exploitative abuse. Also because, as the Advocate General said in the court in response to question 6, which you rightly raised, it is relevant whether a company is dominant in relation to a breach of in relation to the validity of consent, but not because of Article 1 or 2, because that's in the GDPR already, and the GDPR talks about an imbalance of power. And there, the Advocate General, though maybe the language is not hugely precise, the Advocate General is right. This is dominance, you know, imbalance of power can be dominance within the meaning of Article 1 or 2, but can be more than that, right? Can be just commercial power, can be just a larger company, etc. Can be an imbalance of power in a one-to-one relationship. You know, can be different things. So it's already, we already have that in the GDPR in order to look at the validity of consent based on the imbalance of power, and can be a relevant factor in terms of fining under the GDPR. So we really, you know, if we look at this exploitative abuse in this very simplistic way, we are really duplicating. And we are saying, you know, like the Court of Justice, not just in this case, but in B-Post, I mean, we see that in the recitals in the DMA. It's not just a matter of saying, oh, this is competition law. I stick a label here, which is competition law. So it's competition law, it's different. The legal interest is different. But if the facts are exactly the same, and there is no difference, other than a legal label that you stick on it, so where are we? So I think the theory of the judgment is correct, right? Competition law, you can look at the GDPR as an element of this, and the GDPR is different, and maybe the DMA is different, maybe other, you know, telecoms regulation are different. But it's not just a matter of legal labels, however. It's the practical application which is complicated, not the theory. I think the theory of the meta judgment is, you know, more or less, it's fine.
Thank you very much, Renato. Thomas.
Well, first, I do agree with many things that have been said. To be fair with the Bundeskartellamt, they did not go so far as to say explicitly, well, any infringement of the law equates an abuse of dominance if carried out by a dominant firm. They still tried to establish some link there, that it has more effects than just the infringement as such. Otherwise, obviously, any false labeling on your website or whatever, minor infringement of the law would constitute an abuse, and I think we all agree that is not the case. Now where the Bundeskartellamt came from and why they spent 100 pages on the GDPR is really that for whichever reason, I mean, I would have also preferred this more of an exclusionary case where you look more at the barriers of entry and so on and so forth. But they decided they wanted to do this as an exploitation case. And for that, they needed to show that more or less the conditions that Facebook imposed were inappropriate. And for that test of what is appropriate and what is not, they more or less kind of wonder, well, are there any guidelines, if you like, that we have? What is actually appropriate when it comes to the use of data? And then they said, well, there's a general, under German law, there's a general ability that in a competition case, when it comes to assessing the appropriateness of conditions, we look at specific laws that give us guidance on what is appropriate. Copyright, licensing fees, general terms and conditions law, and GDPR for data usage. And that's the link where they said, okay, if the GDPR is really saying this is inappropriate, then this kind of reasoning and this assessment should also be considered in our competition law assessment, like which conditions are actually kind of reasonable and which are not. So it's more to back up this argument. It was unreasonable, this condition, because it even infringed data protection law. And that's, the door opener to then this whole analysis. But it, of course, gave it a bit of a kind of focus that may not have been fully necessary, but from the theory they came from, it made sense. And in a way, well, the judgment now confirms that that was a way that was possible. But again, it does not suggest that the Bundeskartellamt believes that any infringement of any law equates to an abuse. I also agree with Renato when he says, well, it is convincing now of the court that competition authorities need to take in account the legal framework, because ultimately what this is doing is just, it determines the legal scope or the scope in which competition can actually unfold. And if you don't consider the legal framework, you don't really know what the parameters are with which competitors can compete. And you have to determine that so that you can see, oh, well, that's actually a means that is unavailable to others because it's actually illegal, right? So it's only available to you because you basically don't care about these laws, but others do. So I think it's a rather normal approach to look at that framework in a competition case so that you actually know in which scope competition can unfold. But again, as Renato also said, probably framing it as an exclusionary case would have brought more light to the issues at stake and may have helped to have a more thorough competition analysis.
Thank you very much, Thomas. Let me ask you then, what would be the implications of this? First, is the formula itself so revolutionary, or maybe there are other ways to somehow to do incidental, to bestow upon specific authority on themselves some powers to engage in other areas of law if incidental. For example, if you look at the enforcement of the DMA, we have Article 5.2 as an example, where GDPR is explicitly referred to, and we know that without such a formula being available, this would be, the Commission would not be, technically speaking, in position to evaluate the reasonableness or the countervailing benefits, so to say, of specific obligation of Article 5.2. Or is it something which would somehow open the door for other more creative or more instrumental application of more synergetic application of different areas of law? Or it's something which we already have and it's just we didn't confront it on daily basis, and that's why it's such a big publicity and such a big interest in our community. Renato.
Well, I think the judgment doesn't really, I mean, as I said earlier, I think it's not revolutionary in that respect. I think, the legal and economic context has always been referred to by the court in relation to 102, in relation to 101, in fact. Agreements must be looked at in their relevant legal and economic context. So, and if you read the judgment carefully, I think, it shouldn't be revolutionary, because what it says is, and I actually like the word that the Advocate General used, and the court didn't quite use, I think, but which is incidental, right? So that, by which perhaps is something which is very a terminology which comes from perhaps civilian systems of civil procedure, etc. So when looking at the main subject matter of your decision, you may have to look at all other necessary steps, etc., including compliance or non-compliance with other laws, but that is not the main subject matter of the litigation, the main subject matter of the investigation. So it's something that it's a step in the reasoning, but it's not the ultimate subject matter of the decision. So I don't think this judgment should be read. I mean, I'll come in a moment to say, whether it will. I mean, we'll see. But I don't think this judgment should be read as a kind of green light for competition authorities, or indeed other authorities, all of a sudden to start ruling on whether, telecoms companies comply with telecoms regulation, or gas companies comply with utilities regulation, and so on and so forth, and then making a little further step and say, well, this is also an infringement of competition law, and and so on. I don't think the judgment says that, to be fair. As all judgments of the Court of Justice is always a bit, as Alessia was saying, a bit vague, and leaves things a little bit unsaid and unclear. But on a fair reading of the judgment, I don't think it's a kind of jolly for any public authority to start enforcing other sets of rules. That would be a misapplication of it. And my hope is that it will be, it will be applied in that way. However, whether we now for many years we have obviously being engaged in this debate about other objectives that all of a sudden become, or should, according to some, be incorporated into competition analysis, environmental objectives, social justice objectives, etc. And whether some competition authorities, whether under political pressure or because the heads of this authority particularly believe in this new world of antitrust, may use the judgment to incorporate all sorts of other considerations into competition analysis. It remains to be seen. I think it will be up to the courts, the national courts and the Court of Justice, in the end, if my reading of the meta judgment is correct, then to rein back and say, no, this is not what it means. This is not the Far West of anybody enforcing everything, the theory of everything for everybody. No, it is not the way it works. And I think, what makes you understand that, I think, is also all the paragraphs that the Court of Justice, spends to talk about coordination. And so, okay, it may be, some may think, oh, it's another fudge, and etc. But also, in a more positive way, you can look at it as evidence that the court is worried about the Far West of the theory of everything for everybody, and it's actually saying, look, this is exactly not what we want. Therefore, you have to coordinate. Therefore, you have to talk to the data protection authority, the supervisory authorities, or the lead supervisory authority. Therefore, which I find interesting, the decision or a decision by a data protection regulator is binding on the competition authority, so introducing this hierarchy between administrative authorities as well. And so that's how I read also those cooperation provisions or paragraphs that the court spends so much time talking about.
Thanks a lot, Renato, for this. Alessia, what are your views on this?
So I agree with Renato that the judgment is not very revolutionary. I really agree with that, and I do see it as it makes it clear, like the two sides of the spectrum, let's say, are quite clear, right? So one is that competition authorities can have regard to GDPR provisions when they're relevant within the framework in which companies compete. And on the other side is that competition authorities are not allowed to just find a breach of GDPR and say, well, this is an abuse because the undertaking is dominant. But the in-between remains quite gray. And I'm personally a little bit disappointed by this because I don't have any dark sources in the Bundeskartellamt, but from what I heard from German colleagues, there was a little bit the feeling of, well, the point of bringing the case was to explore a little bit what was possible and to kind of bring the whole discourse around the interrelation between data protection and competition law a little bit further. And it was a tricky case from the beginning, but the Bundeskartellamt had thought a lot about the interrelation between these regimes before, and then decided to bring the case, and the case took so long to get to the Court of Justice, and it would have been really nice to have a little bit more from the court on the intersection between them, because I think this is not very revolutionary, it didn't really bring us any further in the debate, really. So we know at least what we can do and what we can do, but all the rest is unclear. So you also mentioned the DMA, which I think is quite interesting, because so we do have now under Article 5.2 a provision related to the GDPR that gives the Commission the ability to think about consent, strangely, I mean, for some, but what I think how it fits within this discussion, and this is where I think it's quite problematic, is that it doesn't solve the issue, which was the issue in the Meta case, that you have a dominant company that gets consent because users don't have a choice, right? This is the whole problem we have here. And now we have gatekeepers that gather consent. And well, how is the Commission going to think about if users have a choice, like if consent is really valid? I think it makes it very complicated now, because if there are gatekeepers, then it's clear that users won't have so many alternatives on the market. So can consent really be freely given in this instance? So now we also have this concept, which is highly problematic already under the GDPR, where it is problematic in the cases in which data controllers are dominant. We have it in the DMA, where all the relevant regulated parties are gatekeepers, so they will also have power. And I think it becomes very difficult then to rely on a concept such as consent. But I think maybe this will take us too much in a different direction. But since you mentioned the DMA, I just wanted to share my thoughts on this.
Thanks a lot, Alessia. Thomas.
Yeah, you started with the question whether this judgment can be interpreted as allowing competition authorities to kind of divert in various legal areas and to second guess kind of the application of those laws. I think if you look in the judgment, yes, there is a sentence that says, okay, competition authorities may need to look in different laws, such as the privacy laws. So it just gave an example indicating that there may also be a need to look into other laws. But I think, as it has been mentioned before, this is a kind of common sense. And if you look at the Bundeskartellamt's reasoning, they were rather clear. They do that only in situations, or they only find the need for that, where they really want to determine the appropriateness of certain conditions, where they then rely upon specific legislation that gives them guidance. I think the idea is made basically if the legislator has decided, well, this is a fair and reasonable condition for granting anything in any sector, then we should take that into consideration when asking ourselves, well, if the dominant company asks for that condition, is that still reasonable or not? And I think in a way you can follow that, but it doesn't mean that the Bundeskartellamt now any other authority needs to turn into a general regulator, right? It only relates to the terms and conditions of trading parties. And where I see a value really of the judgment, I think, is where it actually went a bit further than it was asked for by laying out a procedure how the competition authorities cooperate with specific authorities, that they have to approach them, they should ask them, consult them. If they give the answer, they should pay attention to it. If it's a binding decision, it's binding. But if they don't answer, they can move on and make their own decisions. And if they disagree, they should find consent. I think this is useful guidance for the authorities to really understand what is expected from them. And it's something that wasn't, if you like, totally needed to answer those questions, but where I think the court went a bit further to actually make this a helpful decision. And I think that is useful.
Thank you very much for this, Thomas. I wanted to, before asking this traditional question, I know we're approaching the end of the hour, your recommendations for students, I wanted also to ask, maybe other aspects of the case which appear for you relevant in terms of implications and maybe particularly interesting from purely the vocabulary and legal techniques which have been used. And also maybe in conjunction with this, do you think that while witnessing this wave of proactive competition law sensu lato or sui generis competition law initiatives in different jurisdictions, EU, domestic, and UK, do you think that now we will have less and less need, at least in digital, as far as digital gatekeepers concerned, or undertaking with strategic market status, or in German equivalent, for adopting this very creative, interpretive way of applying the law, enforcing the law? Will the enforcers be granted with more generous competences to competition enforcers to look at these cases more directly? And do we witness this paradigm shift, and now we deal with the previous kind of wave of cases, or the implications, particularly the one which has been mentioned by Thomas now, that we already know a protocol of how we have to enter into the neighboring or any other ultra-virus area will be useful in the future as well?
As I said, I don't know whether you want me to go first, perhaps. Look, as regards the cooperation provisions, I mean, one thing, I think the best evidence that that was not something groundbreaking even was that actually the Bundeskartellamt did exactly that. So the decision, actually, the way they proceeded was exactly to contact the Irish authority, the German data protection regulators, to say, what do you think about that? To, you know, wait for their views, etc. So from that perspective, also, I don't think this is hugely groundbreaking. I mean, one issue that I think will come up, of course, is the status of these decisions. I mean, these decisions by competition authorities on the GDPR or potentially other areas. What's their status in private enforcement, for example, under the Damages Directive? Because we know that under the Damages Directive, the decision by competition authorities is binding on the courts, what is binding in relation to the infringement, but there is certainly in the UK a very significant case law as to what exactly is binding, whether you can apply the abuse of process doctrine, etc. Now, again, I think in theory, the answer should be the decision is binding in relation to the infringement, or is prima facie evidence, you know, if it's before the courts of different member states, in relation to the infringement, but not in relation to incidental issues. I mean, to use that word by the Advocate General. But of course, the practice will be much more complicated than that, and so I can foresee potential arguments, potential difficulties, which are always the case when basically there are these overlaps. But as I said, I mean, these overlaps are, I think, in the current world, inevitable. to a large extent, and it will be down to also a sensible, reasonable application of these principles by all the authorities concerned. I mean, whether the system is going to work or not. I think, the other issue that I see, not just because of the meta judgments, but more broadly, I think for me has always been an issue, is the issue of ne bis in idem, obviously, and which now it's after the B post judgment as well. I mean, it's quite clear. You look at the legal characterization, the legal purpose, but again, I find quite uneasy with this idea that you just stick a different label and you say, oh, you can be punished twice, 3 times, 10 times because this is competition, this is environmental, this is criminal, this is this is GDPR, this is that, this is national, this is DMA. Where does it end if the facts are, after all, absolutely the same? You do not genuinely distinguish this infringement. I do think that the competition infringement is different from a GDPR infringement and so on and so forth, of course. But you have to look at the facts. It's not just a matter of legal characterization, as I said. Thank you. Thank you, Renato. Alessia.
I'll try to be brief in the interest of time. So just one thought. So what the Bundeskartellamt did here really was to try and close a gap, right? So the data protection authority was not, the German couldn't protect consumers because of the system to divide competence under the GDPR. So there was a gap, the Irish regulator was not intervening and the Bundeskartellamt did. So I think that going forward, if the data protection authorities will improve or be better at enforcing the GDPR, also perhaps thanks to this judgment, because I have been a little bit perhaps critical of it, because I think it doesn't help us so much from the competition side to understand, where to kind of draw a line. But I do think it helps by saying that data protection authorities can take dominance into account, or maybe in some cases should take dominance into account. So if data protection authorities start to do that, then they might be able to close the gap that the Bundeskartellamt was trying to close. And then it means that the boundary between the regimes will become clearer. So there will be less need for competition authorities having to actually do something that the GDPR is there for. So that's maybe like a hopeful note at the end. So maybe the boundaries will be clearer, and then competition authorities can focus more on the exclusionary cases, which I think anyway is what the Court of Justice was talking about in this case.
Thank you, Alessia. Thomas?
Yes, if I understood your question right, you were also asking, do we see more of those cases where they need to cooperate with one another? And I agree that that is likely because we have more and more regulated areas of industries throughout, and there is regulation everywhere. So you can't solve a competition case without taking that into consideration. And in particular, when it comes to privacy issues, I think we will see more of that simply because of what the court said. Data plays such a crucial role in the digital economy that you need to know what data uses are allowed and which are not. And this will go in both ways. In this decision, it was whether an unlawful use of data amounts to abuse of dominance. It can also go the other way around. You see many cases where gatekeepers argue, well, we can't do more for competition law, even if you want us to, because privacy and security laws are hindering us. We can't open up Apple, our ecosystem, because security and privacy. And then they pretend that there are some very strict laws or even stricter interests that go beyond the laws that they apparently defend and take that as a justification for not allowing more competition. And I think their competition authorities will have to look at that and clarify in their own investigation, no, what you are claiming here is not justified, because if I look at the law, there is no such thing as a legitimate reason to deny such and such. because this is fully fine with privacy and security laws. And what you are making up here is a kind of a fabricated argument that is not based on any current laws. You may argue that there is some interest in it, but just because you think there is an interest in it doesn't mean you are allowed to limit competition because of that, and we need to balance that. So that is another scenario that already plays a role in several cases where competition authorities need to look at privacy laws and security laws to see, is that really right? Can't they go any further? Can't they open up a bit more? Or is this just a defense that has no merits? So I think the cooperation and the need to look at that will increase, and under the DMA we've got similar issues. So in a way, this is first guidance how to deal with these cases.
Thank you very much, Thomas. I think it's a very interesting point. I should mention to our students that you have recently delivered really impactful presentation on ATT. And we see similar managerial strategy or kind of defense strategy in this regard. So we closed this meeting with, I wanted to ask all three of you to provide brief recommendations to our students. But before this, Renato, maybe in 10 seconds, we all deal with competition law and something else. You deal with competition law, you are an expert in competition law and construction law. Can I just ask you, as a matter of private personal curiosity, is it as exciting, as dynamically developing as competition law, or you do it as without not such a passion and enthusiasm?
I am a contentious construction lawyer, so I do mainly disputes, so arbitration, especially international arbitration. Yeah, it is equally exciting because it's very international. You deal with all sorts of laws and projects in different countries. I have things now in Africa, in the Middle East, in Central America, in Latin America. And it's also a law which requires a lot of, so it's a lot of different cultures and, you know, in different applicable laws and jurisprudence. But also, of course, there are a lot of technical elements. So there is accounting, whether it's engineering and so on and so forth. So just not just law. But what I like about that particularly is the kind of litigation and strategic aspect, which is also something that I like quite a lot in relation to competition law. As you know, of course, I wrote on abuse of dominance, etc., but also quite a lot on arbitration, litigation, and competition procedure. The recommendation that I give in light of that judgment is actually not a new recommendation. I think it's what I always thought, is that the best competition lawyers are always, invariably, in my view, those lawyers who also have looked or have an awareness of other areas of the law. Of course, when you start your practice, or your time is up for sale, so you will do what your clients pay you to do. You have not much choice as a competition official. Also, until you become the head of the agency and you set the agenda to a very large extent, you will have to do what you have to do. It's the cases that come your way, but as long as you are a student, you have the freedom to look broadly. And while, of course, it's important, if you want to be a competition lawyer, to do quite a bit of competition law, also look at other areas such as data protection, but not only.
Thanks a lot, Renato. Alessia.
Yes, so maybe just from my personal experience, when I started my current role as assistant professor, I was labeled as law and tech person. I didn't really know why, because I consider myself a competition law person. But since I had looked at the digital market and GDPR, they just labeled me as law and tech person, which I didn't really understand at the beginning, but now I'm quite happy about it. And I can highly recommend to anybody to get into, I mean, if you're interested, of course, in law and tech aspects, to get into that world, because there's so much more beyond the kind of typical like boxes, like silos that we have, competition law, data protection. There's so much, and it all comes together, and you follow different discussions in different areas of law and tech, and you see how issues of competition law come up everywhere, issues of data protection come up, and there are so many interrelations which make it very complex, but also really fascinating and challenging.
Thank you. And it would be very insane on their side to start this journey without consulting your impressive PhD research, which is available and it's highly recommended as well. Thomas.
Thank you.
I agree to what has been said, and I really believe that if you want to enter the field of competition law, at some point, some special field you have to identify for yourself. And I find it very important that you kind of understand how the markets work in which you want to operate. So some sort of sector focus, or at least openness for all the technical implications, is very important. We are living in a very technical world, and without technical understanding, you won't get that far. That is the same if you look in energy or telecoms or media or digital. You need to be open for the technical aspects, and also obviously the underlying economics, what rule competition in that field. So my advice would therefore be, be open for technical aspects of industries, and if you identify an early interest in a particular area, then go for it and try to apply competition law in that area and make that kind of your individual profile then.
Thanks a lot for this, Thomas. Thomas Höppner, Alessia D'Amico, Renato Nazzini, I'm very grateful for your time and for your expertise. It was really illuminating hour. Thank you very much for this.